How's it going, everybody, and welcome back to Lead Therapy, and thank you so very much for taking time for tuning in to my video. Well, it looks like sometime this week there will be a decision in Congress about red flag laws. So let's talk a little bit about red flag laws and how unconstitutional they are. Red flag laws, often called extreme risk protection orders and gun violence restraining orders, are mechanisms that allow statutorily defined class of people to petition a court to seize the arms of an individual they believe to be dangerous. As enacted thus far, these laws deprive people who have not committed any crime to be deprived of their property and ability to defend themselves without due process. And despite being conflated with mental health reform, red flag laws do not improve access to mental health care or address important issues of untreated or undertreated mental illness. Indeed, red flag laws may even deter who might otherwise seek mental health treatment or counseling. Red flag laws pose serious due process concerns under every implementation to date. The 5th and 14th Amendments under the United States Constitution describe the privation of life, liberty, or property without due process of law, by depriving individuals of property and their rights without formally being charged, arraigned, or convicted of a crime. Red flag laws violate this constitutional right, as so far as orders are issued ex parte, meaning without the person the order is sought against present for the proceedings. Red flag laws invert the presumption of due process. This deprives the accused person of the opportunity to defend themselves or cross-examine the accuser. The ACLU of Rhode Island expressed concern over a proposed red flag law due to the breadth of the legislation, its impact on civil liberties, and the precedent it sets for the use of coercive measures against individuals, not because they have alleged to committed any crime, but because somebody believes they might someday commit one. Put in another way, this Minority Report style legislation purports to predict crime before it occurs, then attach a court order stripping that person of their rights and compelling them to give up or have seized by armed police their property, guns, ammunition, gun parts, etc. Failing to abide by these court orders generally results in serious criminal liability. Those who find themselves subjected to such an order are not typically given a right to an appointed attorney, must engage in a lengthy and onerous process to defend themselves and face difficulty in having their property returned after being seized. Lastly, many red flag laws provide no deterrent to prevent individuals from maliciously accusing others. Whenever somebody contacts law enforcement, whether it be city, state, or federal law enforcement, and they say somebody in the future might commit a crime, what is done, they gather that information, and sometimes they might even go to that person and question them. But a lot of time, they'll put that person under surveillance to build a case, and then they will get a search warrant. They will arrest that person and search their home or vehicle or business and take whatever they need for a court case. So why should any of this be different? Because it shouldn't. Red flag laws are unconstitutional no matter how you word them. People must go through due process before their property is taken away from them. Let me know your thoughts about the story in the comment section down below. And if you enjoyed this video, or if I gave you some information you didn't know, please take time to like, share, and subscribe and hit those post notifications. And I will see you guys in the next video.